International Arbitration Center. I said, what is NIAC? Does it administer arbitration? He said, no. NIAC is an arbitration hearing facility which was promoted by 10 top law firms of New York. Now that facility is one of the most sought after facilities in New York. So hearing facilities are again something which is very, very important. Ethics, enforceability and immunity. These are the 10 principles which makes, according to this 10 commandments, 10 principles of SIAC centenary. And the people who were really author of these 10 principles were Lord Goldsmith, Doug Jones, Judith Gill, Julian Liu, Carol Naren, Toby Londo, Honorable Vivian Ramsey, Peter Rees, so all very celebrated international arbitration personalities. Ladies and gentlemen, we have got today amongst us very eminent panelists. So now we will first start with Jimmy. Jimmy brings in lots of experience and expertise to the table. And now we will start with Jimmy. Jimmy is going to talk about, and I suppose, the nexus between good ADR mechanism and the growth, right to choose the mechanism, right mechanism of ADR, Singapore experiences which we all look at, despite the geographical differences in terms of the size, but we always look at Singapore. In fact, recently I was in Singapore, and there one thing which I liked about was that the Singapore Supreme Court had invited us for a particular talk was to be given to accredited construction lawyers. So Singapore has something called a provision for giving accreditation to construction lawyers, IP lawyers, or a couple of others. Fantastic model to adopt, because arbitration, as I said, is primarily about expertise. And if you recognize the expertise amongst pool of the professionals, you give them accreditation, it is easier for the parties to approach them. It takes lesser time in court because the advocates understand what they are up to, and if you have got especially judges. In fact, it really helps. In fact, few years back, Jimmy, I was in Singapore and for SCL International Conference, and I was asked 3 questions. Do you have construction legislations in India? Do you have specialized construction courts in India? And do you teach construction law in India? And answer to all the 3, ladies and gentlemen, then was negative. But yes, after I came back, I worked hard being the founder and chairman of Society of Construction Law in Japan. We got started. Construction law courses, certificate courses, LLM courses, PG diploma courses, and PhD law in 3 universities to start with. I'm already professor with 3. We are doing it. Mahek is sitting here. She is teaching in some of the courses. So it is going in right direction, but for other 2, whether we have got construction courts, specialized construction courts, we will have to look at to Miller Justice Manullah, and whether we have got construction legislation which takes care of because why I'm talking about construction, because almost 60 to 70% arbitrations in India are construction arbitrations. If you look at the statistics of ICC Paris, around 40% of their disputes are construction and energy. So this is one area that we really need to give some focus on, so that we can really take forward this whole journey of arbitration in right direction. With this now, I'll ask Jimmy to tell us his experiences about what he has seen all happening in Singapore. Jimmy, over to you.
Yes. The Honorable Justice Alam, Amanullah. Mr. Ratan Singh, clearly a senior advocate, the way he argues his points was so impressive. Good morning, everybody. It's a real pleasure to be here. It's an honor. Thank you very much, Mr. Chawla. Well, to start with, Singapore, we follow the 10 Commandments. That should be able to answer why we have such an effective system. Everything that has been distilled in that is true. You need all of them to make sure that you have the right environment for arbitration to follow. But the topic today is effective ADR as a catalyst to economic growth and investor confidence. I wouldn't agree it is a catalyst. I say it's more than a catalyst. A catalyst is something that is necessary to stimulate and cause a change. But it is not a catalyst. It is a precondition. It is a necessary ingredient. You cannot imagine today in any modern country where an investor putting in millions into a project cannot choose the law that governs the contract he enters into, or choose the method by which he decides how disputes are to be resolved. And if you just cast your mind back 50 years, 100 years, no longer than that, any investor coming into a country will have to abide by local laws and local courts, and there were no options. So we have taken a sea change in the way international trade and international economic activity has been, if you look at it. And earlier you heard the session where they talked about how much change has taken place and so quickly. I remember a time not too long ago, just about 1 decade, here in India, judges had a certain disinclination to international arbitration or arbitration. They felt arbitrators were usurping the role of judges. But today, all the judges, particularly the Supreme Court, understand and support the autonomy of parties in choosing arbitration. So change has been rapid. Change is there, and I must say, my London friends here in India and my international friends, we've all practiced law for a while now, and we can see how rapid changes are. So, on the first point, it is not a catalyst. The right to choose an effective form of dispute resolution is a necessary condition to promoting trade, to promoting investor confidence. And even locally, if you think about it, over dinner last night, one of my Indian lawyer friends showed me a study that said that if you did not file an extra case here in India, you would need about 200 to 300 years to resolve the backlog. Now, this is not a criticism of the Indian judiciary or its judges, who work very, very hard. It is this study that came out that many Indian lawyers are aware of. I don't know the parameters of their study. I don't know the metrics. I don't think that's correct. It might be an over-exaggeration. But the truth is, I know my Indian lawyer friends here are hugely busy doing domestic arbitration, because that's a faster route for even local businesses to get their disputes resolved. So it's a clear condition that you have to have a form of dispute resolution that you can choose if you're going to have faith in getting disputes resolved. It's not that we choose to fight. It's just sometimes, as you know, in parties, in contracts, disputes do take place. And of course, the first thing that happens is parties will try and negotiate it. But when they can't negotiate it out, it ends up with us lawyers trying to resolve it for them. The second point I make is this. What are the necessary ingredients of an effective dispute resolution format and mechanism? You've heard all the speakers speak. The judges have given their views eloquently and eruditely. They are quite simple. You need the system that you choose to be transparent, fair, and neutral. That's so important. Now, it may not sound to be so simple, because there are issues in which we take that certain, perhaps, arbitrators haven't declared their interest fully, and we suspect that maybe they're not so neutral. So when those things happen, you get challenges in a court over the awards. But it is crucial. Right? You can't imagine if a judge might have had the scales of justice tipped because he's been approached. You know what I'm referring to. You wouldn't have that. The second aspect is, whatever effective form it is, it has to be robust. By robust, it means that it has to be effective. It has to be binding on the parties. It must stick, in other words, whatever it is. And the third, it must be enforceable. And again, although these fundamentals are agreed by all of us, but our daily and our work experience tells us that sometimes it is not so simple. There are challenges, there are tactics, strategies employed to slow down things. There are issues of challenges that are unfair, unreal. Awards take a long time to be enforced. And there are international awards being... I'm taking a case here in Singapore that has taken 10 years from the time it was first decided and given in England. 10 years has been sought to be enforced and is still being fought out. These are real issues. The third aspect, of course, in order for it to be effective, is that it must be relatively fast. And again, it's easier said than done, but I'm sure many of you have had experiences where some of your arbitrations have taken 5 to 10 years to finally be resolved. And that's where mediation comes in, because a mediated agreement is ultimately an agreement in which both sides have found a common area, and the chances of them being enforced and carried out is much higher. And so that comes to the third point. Apart from arbitration, we've all heard about mediation, and in a while I will also mention the international commercial courts, which is a new creature that's come out in the 21st century, although England has it already in the 19th century. But coming back to mediation, there are a number of things that all of us from our experience know that we need to say. For one, we know that what would be a 3-week arbitration could be resolved if the parties are willing in 1 to 2 days of mediation. A great saving of costs, a saving of stress for the parties, but a drop in the income for counsel. And that may sound scurrilous, but I have to tell you, about 10 years ago, 15 years ago, when in Singapore a judge was been commissioned to start the mediation system, gathered some top lawyers in Singapore to talk about mediation behind closed doors. One of the Singapore senior lawyers said, but mediation would mean we'll lose our income. Now that's a wrong approach to take. That's an ethically wrong and improper thing to do, where counsel puts his own interest ahead of the client's interest. Because we belong to an honorable profession. Our client's interest is paramount. Apart from having to be forthright with the court, our client's interest overrides our personal interest. So earlier in one of those speakers, you heard them say that there has got to be a change of thinking. One of them is this: counsel must be prepared to tell the client the benefits of having something mediated out. But then on the other aspect, there's a level of education that needs to be given to the public, to the clients. That submitting and considering mediation is not because we don't believe in the case, the strength of the case. It's not because we think that we're not going to be able to win the case. It's because it is the client's best interest to consider a form of dispute resolution that is faster, cheaper, and more likely to be enforced. So in that sense, mediation has now taken on a level of importance that Singapore sponsored a convention that was first opened to signature only 6 years ago. In August 2019, the Singapore Convention on Mediation was established. Today there are 22 nations that are signatories to it. Now you take your mind back to the New York Convention. That was in 1958. Over 170 nations. But they didn't all sign it immediately. It took time. So mediation is going to take its traction amongst the nations of the world, and soon you will have 170 nations signing on to the mediation agreement. And why do they need to sign it? Is because it will enable internationally negotiated settlements through mediation to be enforced in the same way you enforce international arbitration awards or international judgments of international courts. And that will come. But is with mediation an issue? In a sense, it is entirely up to the parties to be able to reach a point where they are in agreement. It also means giving up certain aspects. Now here, I have to tell you that there is also a matter of difference in culture. When I first went to practice law and we went to Japan, I realized that in Japan in the 80s, the Japanese don't go to courts because it was their culture to always talk things through. Courts and litigation in Japan only caught on in the 20th century, 21st century. But earlier on, Japanese people settled all the disputes. And litigation lawyers were not common. I'm sure Sweta remember that too. But equally, there are certain sort of culture in different places where people are more litigious. It's not proper to name people by race or by nationality, but I think if you go through your own experience, you will know certain areas of the world is given to a little bit more of a, I need my day in court. I need to fight this out. I can't have them trample over me. And sometimes it's a question of their ego. Sometimes it's a question of their stubbornness. But it is the duty of counsel to run through for them the rationality of being able to have a quicker, faster, cheaper, and enforceable award through mediation. So all the talk about the protocols of NET, they are all being worked out, and they are all sensible options. But it is up to us as counsel to educate our clients that that is a good way forward. But some things are not given to mediation always. Some things that in the nature of the fight has to be fought out. And that we as counsel know. It depends on the facts of those cases and the personalities of the clients that are involved. I now want to have a quick word about the international commercial courts, which is, as I say, a new phenomenon, not because that it has never existed. As I said, England had their first commercial court in the 19th century. But in the 21st century, and I'll read this off to you, the Dubai International Financial, excuse me, the Dubai International Financial Center was established in 2006. The Qatar International Court of Dispute Resolution in 2010. Singapore established ours in 2015, and we have Justice Sikri sitting on it. The Astana, Kazakhstan was established in 2018. The Netherlands Commercial Court 2019. Belgium, Brussels International Business Court 2020. Bahrain, and as you know, your Justice Kaur was invited as one of his panelists, and so is Dr. Pinky Anand. I hope she's here. And she's a panel member on that Bahrain International Commercial Court. And Switzerland is considering having one enacted in 2027 next year. It's a new phenomenon in a sense, as you can see all the countries rushing to it. It has certain attributes different from international arbitration. You don't choose your arbitrators because you don't choose your judges. That in a way has its attraction in some sense, but for those in the arbitration world, they say that it detracts from parties' autonomy. This is not the session to quarrel who is right. There is also, in a sense, a greater firmness in which directions and orders are given when it is a court. I think you will see that in arbitration, arbitrators tend to be more consensual, more respectful, because the parties pay them to be there. In an international court, you don't really pay the judges to be there. The system pays the judges to be there. You may pay some court hearing fees. So the judges don't feel so beholden to the parties and do come down harder on the parties. So that's a new phenomenon. And through the Hague Convention on the choice of court agreements, as well as bilateral agreements being established, international court awards are being enforced almost in the same way as international arbitration. For Singapore's International Commercial Court, we now have a panel of 26 international judges, and through the Hague Convention, through the bilateral treaties, through the various agreements reached, I think the awards of the Singapore International Commercial Court is enforceable just about in every civilized nation. And that's another form. But I come back to what Setna said earlier, which I found very attractive. She said the catchword in Singapore now is not to call it alternative dispute resolution to the local courts, but to call it the appropriate dispute resolution. And I think that's right. It is up to us as lawyers to advise our clients. It may not be us dispute lawyers. It is the transactional lawyers that need to know all of this to be able to recommend what goes into the contract. And they are no longer midnight clauses. These dispute resolution clauses are important clauses. Thank you very much.
Thank you, Jimmy. Here in Singapore experience, prompts me to say something since Justice Amanul has said it. A couple of years back, I was chairing one session where Michael Huang was one of the panelists. There, Michael said that in Singapore, if you appear before a court and say that kindly accommodate us for a particular day or a particular week, because I have arbitration hearings, courts willingly tell their lawyers, don't worry, we'll have it after those days. But when it comes to India, when we appear before courts and we say that kindly accommodate, don't have date on that particular day because I have arbitration on that week, generally courts are reluctant and sometimes they get upset, they do not take it in good taste. They say if you want to do arbitration, do it arbitration only, don't come to the court. In UK also, arbitration bar did not become arbitration bar in one day, and even today, a lot of arbitration lawyers are appearing in courts because sometimes if they have done the arbitration, they are requested by the parties to appear before the court as well. So this is one thing we will urge on behalf of arbitration practitioners to Justice Amanul to send word across the judiciary that if arbitration lawyers are requesting for accommodation on dates, it will be really great achievement of this ICA conference that this will really help a lot of arbitration lawyers sitting here. So that was one thing I thought I must say.
I'll respond to that immediately because maybe I'll forget. No, your point is taken. I'll tell you the mindset of a judge. You have to understand what before the judge is the proposition. You ask for time in a case, the ground is arbitration. But normally now in the Supreme Court, before me, more than 3 years on the bench by now, not even one lawyer has made this because I know for sure whoever is the arbitrator, maybe a former judge or whoever, they fix their cases so that it is convenient for the lawyer not to miss their actual litigation time, either it's in the evening or on court holiday. Very rarely they have to accommodate because that request has not come. But coming mainly to the point, as you said, yes, definitely, then you have to understand that before a judge, if arbitration